essential and necessary. The interaction between the national jurisdictions themselves and their interaction between themselves and the international jurisdictions is an essential opportunity for learning, for sharing of experiences, and it is something that should continue. The opportunities are there even when the ad hoc tribunals close for other fora, such as the ICC, such as the International Association of Prosecutors, to provide some umbrella for these kind of consultations to be able to continue. So, notwithstanding that it may be our last year as the ICTR next year, we do expect that this kind of consultations and fora will continue. We have adopted the resolution, and I would like to call now upon the Chief Rapporteur of the conference, Madam Teresa Berrigan, to read it out for all of us.
Good afternoon. We, the prosecutors and participants of the 7th Colloquium of International Prosecutors, held under the auspices of the International Criminal Tribunal for Rwanda in Arusha, Tanzania, taking note of the 20th anniversary of the Rwandan genocide of 1994 and of the 20th anniversary of the establishment by the United Nations of the International Criminal Tribunal for Rwanda, emphasising the importance of accountability for international crimes, which are gross violations of human rights, in the interests of justice, peace, security, and the well-being of the world, as well as the role and responsibility of the international community in ensuring such accountability, welcoming the efforts of the international community and the contribution of the international and hybrid courts and tribunals, as well as national, judicial and other authorities in combating impunity for international crimes and ensuring justice and accountability, recognising the need for effective partnership and enhanced synergies between local and international justice efforts in order to secure in a comprehensive manner accountability for international crimes, recalling the primary responsibility of states to investigate and prosecute such crimes, and the need for them to take effective measures to ensure the full discharge of that responsibility, including through the provision of conditions which, inter alia, support an impartial judiciary and an independent, effective and well-resourced prosecution and defence, recalling further that it is incumbent on the international community to foster conditions necessary to enable genuine, fair and effective national prosecutions in communities affected by mass criminality. Now, therefore, call on the international community, together with national authorities, to provide adequate support to the ad hoc international and hybrid tribunals, their respective residual mechanisms, and the International Criminal Court, to enable them to fully implement their critical independent mandates. Request the international and hybrid tribunals to intensify their work on best practices and lessons learned, and projects for the compilation and sharing of such lessons and practices, so as to provide guidance in the local and international prosecution of international crimes, and for the international community to support such projects. Further request states, in particular judicial and other national authorities, to share experiences, practices and lessons, to assist in the prosecution of international crimes, and in doing so draw from the experience of international courts and tribunals. Call on all states to adopt appropriate measures and strategies to end impunity and thereby contribute to the prevention of the commission of international crimes, including through the creation and support of the necessary conditions for justice and respect for human rights within their jurisdictions. Further call on all states to ensure the adequacy of their laws and legal systems, to enable them to discharge effectively and fairly their primary responsibility for the investigation and prosecution of international crimes through, inter alia, the ratification of relevant international treaties and the adoption of implementing legislation. Urge the international community to establish and support existing effective mechanisms for the training of personnel and capacity building of local systems for the prosecution of international crimes, and for supporting local prosecution of such crimes to ensure effective compliance with international standards. Further urge the international community to provide adequate support to states to enable them to implement necessary measures to empower their legal systems to prosecute such crimes. Call on the international community and national authorities to deploy greater efforts to ensure effective accountability for all international crimes. Done here at Arusha, Tanzania, this 5th day of November 2014.
It is now my pleasure to introduce the speakers for the closing ceremony. We will not take them in the order that you have on the agenda. We've changed the order a bit. I think we will start with U.S. Ambassador Stephen Rapp, Ambassador for Global Justice, Global Criminal Justice. The United States has been a very, very strong partner of the ICTR and of the global struggle for accountability. We, on our part in the ICTR, have benefited immensely with U.S. assistance in various fields, in the provision of evidence, in provision of personnel, in provision of, in support of our tracking efforts. As a matter of fact, the U.S. Rewards for Justice program has helped immensely in ensuring the arrest of the majority of our indictees. Ambassador Rapp himself, of course, is not a newcomer to international criminal justice. He's been with the ICTR as a senior trial attorney, leading the media case, not so? Yes, he dealt with the media case, which was a very novel case in international criminal law. And from there, he proceeded to become the prosecutor of the Special Court for Sierra Leone, and now U.S. Ambassador for War Crimes. Ambassador Rapp.
Well, thank you very much, Hassan. It's great to be here, and it's been an extremely rich discussion, but it's thrilling to see a full room and the enthusiasm for continuing and increasing the efforts in accountability for these crimes of international concern, of genocide, war crimes, and crimes against humanity. I remember the first time, I think it was now, as I recall, in November of 2008, when you held the conference calling national prosecution authorities together, and I came over from Sierra Leone, and at that time we were already looking at the closing of the tribunals and noting that between the ICTR and ICTY and adding in the ad litem judges in Sierra Leone, there had been like 53 judges particular at the high point that were serving in these tribunals and deciding cases and writing judgments and enriching the jurisprudence in this area. And we were looking for the day when there would be no one continuing to do that job, and where we'd have the ICC certainly with 18 judges taking up its role as the global court of last resort. But there had been this perception that this project was going to diminish in the future, that there was going to be less intensity, less interest, less high-level engagement. And certainly my role in this job as ambassador at large has been to travel, as you know, a great deal. I get out 220 days a year, been to about 75 countries now, 1,100 days on the road. And what I discover is that because of the work of these tribunals, that the expectations for justice are higher than ever. People have seen Charles Taylor brought to trial and convicted, Milosevic brought to trial, Kambanda, Prime Minister, convicted here of genocide. And they ask, what are the crimes that were committed in our country or being committed today? Where is there justice for us? Sometimes that may be at the ICC if it's a case where the ICC has jurisdiction. Sometimes it may not be immediately evident, but the demand is there, and it's greater than ever before. And it's up to us in this room to work to meet that demand, to meet the justified expectations of justice for people in our countries and across the globe. And I think we have to recognize that as the ad hocs close, as you'll no longer be able to convene a session like this, it requires us to reinforce our efforts and reinforce our connections, and also to recognize that that there will be and necessarily must be efforts beyond the ICC that transcend national borders, but that those will, I think, be increasingly fixed within national systems with some international characters added. And thrilled to see our friends from the and the motion moved just a few moments ago by the prosecutor of the extraordinary chambers, extraordinary African chambers, dealing with the crimes in Chad in the 1980s during the regime of Hissène Habré, and those cases being brought forward in Senegal. I think we'll see that model adopted elsewhere, where within a national system there will be a degree of internationalization to provide greater resources, capacity, and sometimes the advantages, as we saw because of the decision of the ECOWAS court. It was necessary to have a court of international character to do some of the things that you need to do in cases of this importance. I noted in May, the Secretary General called for a special court for South Sudan, and President Obasanjo, former President Obasanjo of Nigeria, responded, and he's, as you know, the chairman of the African Union Commission of Inquiry on South Sudan. He said, well, let's look to the model of Senegal. Let's look to a court that could be a partnership between South Sudan, the United Nations, and the African Union. And I think that may be a constructive way forward, but obviously a lot of work will need to be done to get there. I was to the Central African Republic in April. I'd hoped to go back in October, and the security situation didn't allow it, but I hope to soon return, and we have our friend, the Prosecutor General here, whom I met when I was there in April. But as he's discussed, one of the ideas is to have a special criminal court there within the national system with international participation of judges and investigators from Francophone African countries. And this has been proposed by Interim President Samba Panza. Memorandum of Understanding has been signed with the African Union. And if that now goes forward with legislation at the national level, it's going to be incumbent on all of us to work together to make that a success. At the same time, that we strongly support the investigation by the ICC of the senior leadership responsible for the crimes. A court like this may be necessary to go after the mid-level individuals that are committing the crimes and to help, in the end, to reinforce the national system that's left when that court phases out or when the international participation phases out. So a lot is happening and needs to happen in this area. And I think all of us need to work together. And particularly, and finally, and I've had we've been great discussions here from the panels, but there's also been discussion on the margins. And I was talking to a prosecutor who said, that one of the essential things, and it's referred to in terms of the partnership in this resolution, is certainly to increase the cooperation between ourselves and between our offices, and to eliminate the barriers to that cooperation. as you may be familiar, the Dutch government, together with the Belgian government, and now a series of governments, including some in Africa, are proposing a new international convention for judicial cooperation between states on atrocity crimes. And we'll see how that moves forward. But it's a very interesting proposal. But we all know that a new international convention will take time to ratify, take time to implement. But before we arrive at that day, I think, as someone suggested to me, we need to open those informal points of contact and make sure that everybody has everybody else's fax number, and there's a way to contact each other, and when there's a request, and discuss it informally, and make sure that when the request comes, it fits local law and procedure, and that it doesn't get lost in the mail, and that we respond in that way. And I hope that out of this forum today, we can work to develop those kinds of connections, because so often the evidence of these crimes, some of the witnesses are not within the jurisdiction where the crimes are being prosecuted. Certainly that's the case when it comes to these units like in France and the Netherlands and Canada and elsewhere where they need that cooperation, but it's also true between countries on the African continent and everywhere. So I hope that out of this session we gain renewed energy and renewed and strengthen in the end the capacity for global justice. My office used to be called War Crimes Issues. We changed it in January of 2012. We didn't take the term international because most people think that's the kind of thing done exclusively at the UN or with courts that are established by international convention or treaty. It's a global process. It happens at the international level. It happens at a mixed or regional level. It happens in national systems. And every part of that system needs to be reinforced if we're going to meet the expectations of those that have suffered the worst crimes known to humankind, and to build on the experience that we've had here in how to do this in a fair and a just way, where those who are guilty can be, the evidence can be found, and they can be judged guilty, and where the innocent are found innocent because of an effective defense and because of the resources that are necessary to find the exonerating evidence or to challenge the prosecutor's evidence. So this enterprise is not diminishing, in my view. It's one that's being increased, but in different ways. But it relies on all of us, and that's why I'm so thrilled to come here and to join Prosecutor Jallow and the Legal Counsel of the United Nations and Brenda and all of you to make sure that the future will be one where there's greater justice, greater accountability for these crimes because of the foundation that we and you, all of us, have laid. Thank you very much.
Thank you very much, Ambassador Rapp. I'd now like to call on Prosecutor Brenda Hollis. She's also a very familiar figure in the global struggle for accountability. She was with ICTY, I believe, first, as a lead prosecutor there, and moved on to the Special Court for Sierra Leone also as prosecutor, and now is the residual prosecutor. Not residual, prosecutor of the residual mechanism. The mechanism is residual. You are still a full prosecutor. Prosecutor of the residual mechanism for the Special Court for Sierra Leone. And I'd like to invite her to say a few words.
Thank you, Prosecutor Jallow. And what he really means is that I'm quite old. I think that's what he means. First, I would like to take this opportunity to congratulate and thank the Rwanda Tribunal for 20 years of developing international criminal law and thus bringing us closer to ending impunity for these international crimes. As we all know, in the 1990s, the torch passed from states to international criminal courts to determine criminal accountability for international crimes, because states at that time were unable or unwilling to undertake this task or to undertake it in a fair, impartial, and independent manner. 20 years later, we see that the torch has been passed back to states as primary actors to investigate and prosecute these crimes, which are gross violations of the human rights of the direct and secondary victims, and also strike at the heart of a state's ability to function and to provide necessary services and security to its citizens. The passing of this torch imposes awesome responsibilities and duties on states, with support and assistance from the international community and international criminal courts. These responsibilities rest with all states, ICC members and non-members, because after all, these crimes offend every member of our global community. Therefore, my remarks are addressed to all states. All states now have the duty to ensure that their laws criminalize these international crimes with no immunity for these crimes. And I applaud those states who have expanded this criminality beyond the 3 core international crimes. States now also have the duty to ensure that their rules of procedure and evidence, including time limits, reflect the reality of the context in which these crimes are committed. This is of particular importance in relation to crimes of sexual violence, which are usually committed in inherently coercive circumstances with no ability to promptly report and no ability for forensic evaluations. If states do not have such criminal laws and rules of procedure and evidence, those are long overdue, and I encourage you to enact or incorporate them now. Passing of the torch also imposes the duty on states to ensure they have effective mechanisms to investigate, prosecute, and try these crimes, respecting the rights of suspects and accused persons, and ensuring the rights of victims and both prosecution, defense, and court witnesses, to provide sufficient resources, facilities, finances, and other support for all those involved in the process, including those who provide defense services to suspects and accused persons, and to provide appropriate support to victims and witnesses. It also imposes the duty on states to take all necessary steps to maximize transnational communication, cooperation, and coordination, including streamlining steps that are necessary to gain investigative judge, prosecution, and defense access to victims and witnesses and other evidence, access to crime scenes, to apprehend and transfer suspects and accused persons, to assist with protective measures, including allowing relocation of protected persons to their states, to facilitate video link interviews and testimony, and the taking of depositions. And in this regard, regional actors would play a significant role in this endeavor. If states do not effectively carry out these responsibilities, I respectfully suggest they should not be heard to object when the torch passes back to an international criminal court. I also respectfully suggest that if states truly have the political will to take up that torch, the bottom line is reflected in the Nike slogan, "Just do it." Challenges and obstacles are complex, but they have solutions when there is true political will. The good news is that states are not alone in the wilderness when they are just doing it. We are all in this endeavor together. The law and rules of procedure and evidence are there. The Rome Statute and its rules, its jurisprudence. The comprehensive body of jurisprudence, both substantive and procedural, that has been developed by the Rwanda Tribunal, the Yugoslav Tribunal, the Special Court for Sierra Leone, as well as their rules, the jurisprudence emerging from the Lebanon Tribunal, and the jurisprudence from states that are prosecuting these crimes. It is there. Use it. Universal jurisdiction exists. Just use it. Many individuals from countries throughout the world have acted as investigators, prosecutors, defense attorneys, judges, victim and witness support personnel, and administrators in the international courts, and they have now returned home. Use them. International organizations such as JRR provide expert assistance, and other international experts are available throughout the world. Just use them. There are many lessons learned by international courts and state actors. Manuals and checklists have been created. Just use them. Communicate, cooperate, and coordinate with national actors in other states regarding your common challenges and solutions. We have here today a room full of committed professionals dedicated to ending impunity, to bringing timely and fair justice to the countless victims of these terrible crimes and to those accused of these crimes. Let us all work together to just do it. Thank you very much.
Thank you very much, Brenda. Since it was founded in 1945, the United Nations, we all know, has been deeply engaged in fighting for human rights, fighting against injustice, and promoting accountability. As a matter of fact, that's one of the objectives that the Charter itself spells out. Within the UN structure itself, the Office of Legal Affairs has been playing a very, very crucial role in the area of international criminal justice. Each one of the statutes of every tribunal which exists today, each of the statutes was actually conceived, crafted, nurtured, and overseen by the Office of Legal Affairs. So the international community actually owes a debt of gratitude to that particular office. And we are very delighted that today Mr. Suarez, its current head, legal advisor to the United Nations, Under Secretary General, is here on behalf of the Secretary General of the United Nations to say a few words to us. You're welcome, Mr. Suarez.
Ladies and gentlemen, allow me two special greetings before I start. The first one is to you, Prosecutor Jello. My dear friend Hassan, thank you for inviting me. It's yet another opportunity to express the United Nations commitment to international criminal justice, as well as my personal commitment and the Secretary General's personal commitment to the fight against impunity and to the building of a true age of accountability. And my second special greeting is, of course, to Prosecutor Bensouda. I'm happy to see you here, with my admiration for all the extraordinary work you have been developing over the last years. Now, it's a pleasure to address you this evening as we close this Prosecutors Colloquium, following 2 days of engaged and stimulating discussion. Over the past 2 days, we have considered many factors relevant to the prosecution of serious international crimes at the domestic level. I wish to touch on several of those factors in the course of my remarks. Tomorrow, we will open the symposium commemorating the 20th anniversary of the establishment of the International Criminal Tribunal for Rwanda. It is therefore fitting that we look to the context of the tribunal's establishment as a starting point. The Security Council acted under Chapter 7 of the Charter of the United Nations when it established both the ICTR and the International Criminal Tribunal for the former Yugoslavia. The ICTY and ICTR are subsidiary organs of the Security Council, and member states are required to cooperate with them. This duty to cooperate is given expression in the tribunal statutes, and the tribunals have primacy over domestic courts. The crimes over which the ICTR and the ICTY have jurisdiction were considered by the international community to be of the utmost gravity, and therefore action under Chapter 7 was the appropriate response. From the outset of the tribunal's existence, therefore, the need for cooperation with national legal systems was clear to the international community. As the tribunals proceeded with their work and moved towards completion of their mandates, however, it became clear that cooperation would be required from national authorities in several respects. On the one hand, we can identify the types of cooperation necessary for the tribunals to carry out their work, the execution of arrest warrants, provision of evidence, facilitation of witness attendance, and execution of sentence. On the other hand, as became a matter of increasing importance, we see the role of domestic prosecutions themselves supporting, enhancing, and indeed complementing the work of the tribunals. This therefore brings me to the principle of complementarity. Over the past 2 decades, the centrality of this principle to our system of international criminal justice has become ever more clear. The Office of the Legal Counsel works closely with the international and United Nations assisted criminal tribunals, as well as with the International Criminal Court. Our work covers a wide range of matters related to the operation of those institutions. And that work includes cooperating with national authorities, whose work complements that of the tribunals and of the ICC. In this regard, we review requests for the provision of United Nations documents for use in national criminal proceedings, cooperating where possible, subject to considerations of confidentiality, privilege, and the interests of the organization. We accompany staff members and experts on mission who have been called as witnesses in domestic proceedings, supporting them in providing their testimony and advising them on their applicable privileges and immunities. We consider supporting national proceedings in this manner to be of fundamental importance. Our work with the international and United Nations assisted tribunals gives us a unique insight into many of the reasons why complementarity is essential. The challenge of resources in the context of the international and United Nations assisted tribunals, particularly those which are funded by voluntary contributions, is a matter with which my office engages on a daily basis. We are well aware of the difficulties which constrained funding places on the smooth operation of judicial proceedings. It is well known that international criminal justice can be costly, both in terms of resources and in time, in human resources, and in money. The cases which have been prosecuted before the international jurisdictions are generally the most complex, the most high profile, and of the greatest significance. However, the international criminal tribunals and the ICC simply cannot be the venues before which very large numbers of perpetrators are prosecuted, nor, I would submit, should they be. There are very many benefits to cases being prosecuted at the local level where possible. Conducting prosecutions closer to the locations where crimes were perpetrated facilitates the gathering of evidence, the participation of victims and witnesses, the access of local media and civil society, and the impact of the proceedings on local communities, including in the context of reconciliation efforts. The sight of a once powerful political or military leader in the dock can be of enormous importance to a people which has come through atrocities. The symbolism of such a figure brought before a group of independent judges is a very important image, even before trial is conducted and judgment rendered. Embedding a culture of accountability within a domestic legal system plays a fundamental role in enabling a society to move forward after conflict. It is also essential to developing a legal system that is sensitive and protective of the rights of all persons within its jurisdiction. Put another way, the work of the United Nations both assumes and demands that there can be no peace without justice. Over and above this, however, strengthening domestic legal systems, building capacity, and improving institutions of good governance at the state level will have a lasting impact on fractured societies. I also consider that it is important that, where possible, states take responsibility for their own matters, including criminal prosecutions. Indeed, the establishment of the ICC as a court of last resort reflects the recognition of that importance. Having said this, and as we have heard over the past 2 days, there can be many challenges to successful prosecutions of serious crimes of international concern at the domestic level. The Office of Legal Affairs was intimately involved in setting up the international and United Nations assisted tribunals, and the reports of the advance missions prior to their establishment highlight many of these challenges. Serious international crimes are most often committed in the course of armed conflict, be it international or non-international. Commencing legal proceedings in the chaos or immediate aftermath of war may be simply impractical. Legal systems are often left decimated, with institutions simply unable to function and the near total dearth of capacity. There may be a lack of basic infrastructure, including a functioning court system. The perpetrators of atrocities may remain in power and exert influence, leaving victims and witnesses too afraid to testify before nascent legal proceedings or susceptible to unacceptable risks of harm after having taken courageous decisions to be part of such proceedings. For these reasons, at least in the immediate aftermath of conflict, conducting prosecutions of serious international crimes outside the state in which the crimes were committed may be preferable. In the past 2 decades, however, we can identify a role for complementarity even in circumstances in which the national legal system of the country concerned does not yet have the capacity to prosecute the most serious crimes in application of full due process and fair trial standards. Other states, which may be able to exercise jurisdiction, can and should consider doing so in order to prosecute serious international crimes. The principles of aut dedere aut judicare, set out in a number of key international treaties in respect of serious crimes, is a valuable additional element in this regard. The accountability options presented by this framework are an important element in fully closing off any impunity gaps that may result from the interaction of differing national legal systems. In the long term, however, the challenges which face national jurisdictions in bringing their own prosecutions can and must be overcome. National prosecutors have a key role to play in that regard, collecting the evidence, weighing the strength of the case, and leading trial proceedings. It was fitting that yesterday afternoon was devoted to the sharing of reports from national prosecutors on the implementation of their mandates to prosecute international crimes. The international and United Nations assisted criminal tribunals have developed a broad wealth of experience and expertise over the last 20 years. It is incumbent upon those who have built up such a reservoir of knowledge and skills to share them with national counterparts. I am aware of many of the initiatives in which the tribunals are engaged to broaden the knowledge and expertise of national counterparts. I commend the prosecutors and their staff and the other entities within the tribunals who work on these matters for all these efforts to transfer their hard-won skill and experience. Moreover, in an increasingly interdependent international community, the role of regional organizations and institutions becomes of greater importance. This principle applies across a wide range of issues, and the prosecution of serious international crimes is no exception. We heard this morning discussion of the ways in which such institutions may contribute to the prosecution of such crimes. Where these would facilitate efforts, I would encourage the sharing of information and expertise in pursuit of this common goal. It strikes me that the core theme which has run through the discussions of the previous 2 days, namely the importance of complementarity and the centrality of that principle to our system of international criminal justice, is one which I am certain will be the subject of further discussions during the symposium of the ICTR's legacy over the next 2 days. Translating the understandings won over the ICTR's lifetime into strengthening the ability of states around the world to deter and punish international crimes will itself be a worthy achievement. I therefore look forward to building upon the work of these 2 days in our ongoing discussions and indeed in the long term as we continue to support national institutions across the full range of legal cultures. Thank you.
Thank you very much, Mr. Suarez. I'd like on your behalf, on my behalf, to thank all our 3 speakers for their excellent presentations and for the suggestions they have made in their statements. This colloquium, of course, is only the first stage of the events marking the 20th anniversary. We end the colloquium today, but we start the Legacy Conference tomorrow morning in the same venue and at the same time at 9 o'clock. And I believe every participant at the colloquium is also welcome to attend the Legacy Conference. Beyond that, it's been a very good 2 days, and if we were perhaps to use the UN evaluation system, we'd say it exceeded our expectations. It's been substantially, it's been a good outcome. I think together as prosecutors, we've been able to respond very well to this transitional phase in international criminal justice, transition from primacy to complementarity, and give our own views as to how we think this principle of complementarity could be strengthened. That is not the end of it, of course. The states have roles to play in implementing the measures we have indicated or recommended. International organizations also have a role to play in that. We ourselves, of course, should continue to be in the vanguard for the struggle for justice and for accountability. Ensure that our national systems, particularly for the national prosecutors, ensure that our national systems are provided with the equipment, with the means, with the wherewithal that they need in order to discharge their responsibility. I'd like to thank you all for having attended the colloquium. Many people need to be thanked. First, our sponsors who provided the funds to enable us all to gather here. The Secretariat, which has been running things behind the scenes, the Legacy Committee of the ICTR, the OTP Colloquium Committee members, our good interpreters, of course, but particularly you, the participants, without whom, of course, this outcome could not have been achieved. I'd like to thank you all once again from the bottom of my heart, as they say. Thank you very much. Now, I only want to say that officially the 7th colloquium has come to an end. You are not traveling back home yet, so see you tomorrow morning for the Legacy Conference. Thank you very much. Thank you. I have one request. The international prosecutors should stay on together with some national prosecutors for us to talk to the media. They've requested a chance to speak to the prosecutors.
Tea is also being served in the lobby this afternoon, and also please remember that dinner will be at 1900 in the same place as last night. Thanks.